Good morning, this is your Kelso Report for Monday, December 12th, and I'm your host, Clark Kelso. We only have 4 one-liners for today. First, in Bravo versus City of Santa Maria, the Ninth Circuit reversed a summary judgment which had been granted in favor of the city on the plaintiff's Section 1983 action arising out of a nighttime SWAT team search of the plaintiff's home for weapons suspected of being used in a drive-by shooting. The search warrant application failed to disclose that the person who supposedly participated in the drive-by and stored the weapons at the house was actually incarcerated in state prison at all relevant times. The Ninth Circuit held there was a question of fact about whether the omission was deliberate, because there was a question of fact whether the detectives who conceded they had reviewed the suspect's rap sheet actually knew he was incarcerated at the relevant times. The Ninth Circuit remanded for trial on that action. Next, in the area of government law and recoupment, in Allende versus CHP, the First District upheld CHP's policy of presumptively treating as an emergency any dispatch of an officer in response to an incident involving a person driving under the influence of alcohol or drugs. Now, the ultimate determination of whether there was an incident requiring an emergency response is left under CHP's policy to the discretion of the responding officer, subject to internal review. The relevant statutes, sections 53.150 through 53.159 of the Government Code, allow public agencies to recover emergency response expenses from persons who intentionally or negligently cause incidents requiring an emergency response. The court upheld the CHP's interpretation of these statutes. Next, in the area of attorney's fees, in Kargil versus Sousa, the Fifth District reversed the trial court's refusal to award attorney's fees to a contracting party who prevailed as defendant in a suit brought by a purported third-party beneficiary of the contract. The trial court had ruled that the fees clause in the agreement did not apply to third-party beneficiaries, but the Fifth District disagreed, concluding that if the purported third-party beneficiary had prevailed on its complaint, it would have been entitled to an award of attorney's fees. So, under the principle of reciprocity, the defendant was entitled to attorney's fees when the trial court granted summary judgment in the defendant's favor and dismissed the purported third-party beneficiary's complaint. What goes around comes around. Next, in the area of latches, in San Francisco Opera Association versus Flickinger, the First District ruled against the San Francisco Opera in its attempt to collect damages and interest based on an executor's failure to distribute assets of an estate to the opera. The executor had obtained a final order for distribution way back in 1999, but did nothing further to implement the order. 10 years later, in 2009, the opera finally filed an action to surcharge the executor. The court agreed that the executor had breached his fiduciary duty, but found that the opera was limited to statutory remedies in recovering what remained of the assets. According to the court, the opera's 10-year delay triggered a laches defense, which barred any claims for damages not based on statute. Fortunately for the opera, there was no commingling or misappropriation of the funds. Finally, in the area of employment law, in Henry versus Red Hill Evangelical Lutheran Church of Tustin, the Fourth District rejected an ex-employee's claim for wrongful termination when the Red Hill Lutheran School terminated her for living with her boyfriend and raising their child together without being married, contrary to church doctrine. The court held that the church does not qualify as an employer under the California Fair Employment and Housing Act, that the termination was for religious reasons for which the church and school are exempt under Title VII of the 1964 Civil Rights Act, and that the claim for wrongful termination in violation of public policy was barred by the ministerial exception. And that's it for today's Kelso Report. Have a great day in the law.